Hi, I'm Jim McNeilly. I'm here with Kurt Carlson. We're with Carlson LLC, a law firm with offices in Wisconsin and Chicago, and we're going to talk today about how to collect a debt. So Kurt, tell me what you believe to be the key to a successful collection.
I think the primary keys are leverage and information. I think information, like the old maxim says, information is power. And information can certainly provide you with very good data, very good background in order to see what the strengths and weaknesses of your client's position are. But in terms of collecting a debt, what information is available to you. Information is critical. The other piece is leverage, and oftentimes the type of leverage that we're using is notifying the guarantors, and sometimes that's a spouse. And oftentimes when you're sending out a demand or a default notice, that's the first time the guarantors or people other than the principal of the company that you might be suing to collect a debt on, might be the first time that they hear that there's an issue. And allowing that spouse or those other guarantors the ability to hold the principal of the company accountable, now you've got a partner in terms of holding the principal accountable and somebody working with you to try to collect that debt.
In our article, we've got 5 steps. We've outlined 5 steps for the process. And I'd like you to tell me a little bit about each step that you think is important. We've already talked about necessary information. What kind of information do you find useful?
Well, there's all kinds of information in a client's credit file. And the credit file is a little bit different than the client's loan file, which is going to have the promissory note, the mortgages, the guarantees, and whatnot. But the credit file is actually going to have the information about the borrower and about the guarantors. And you can use that information, and sometimes that credit file will have a tax return. And you can use that information to see that they had, at least in a picture and a moment in time, this is what their assets were. And down the road, now that this is a debt that needs to be collected, it provides very good material to inquire about the borrower or guarantors. Where did those assets go?
Step 2 is determining the nature of the obligation. And why is that important?
Well, that's also goes back to the leverage point, Jim, because the type of obligation, if it's an unsecured debt, it doesn't give you a whole lot of leverage if it's just a straight unsecured debt. But if it is secured and it's secured by business assets, oftentimes those business assets are the sole source of income for the borrower and sometimes the guarantors. And if you start making noises about possibly attaching business assets or getting a receiver appointed, that can really serve as some effective leverage and negotiating strength for the principal to stay in a position where they're still adding value to the borrower that would justify their drawing a salary and staying in the picture in terms of making this company turn around and be prosperous.
Many obligations don't require a default notice. What do you think about sending out notices of default?
Default notices are good for a lot of reasons. Number one, they're generally required, but it's sending out the signal to the borrowers, to the guarantors, to other people, and that might be their first indication that there's a real problem here. Sometimes it's the first indication for the borrower that there's a problem because they've been paying their debts and they've been paying the loans, but what they don't realize is that there's a covenant default with the loan documents. And oftentimes it's important to put into your default notice what the defaults are. So if a borrower has an asset-based loan where their collateral is accounts receivable and their accounts receivables dip below a certain threshold, that constitutes a default with the loan-to-value covenant contained in the loan documents, and that default letter might be the first indication they have that they have a problem that the bank is taking seriously.
The next step would be bringing a lawsuit. And what considerations are there before you do that?
Before I bring a lawsuit, the default notice and the communication with borrower's counsel is important, because filing the suit is their last resort. And as I tell a lot of clients, the moment you file suit, you're turning your life and your decision on this credit over to a third party to adjudicate and determine rights. And so bringing the suit is really a last straw. And we file suits only after we've exhausted our ability to try to work out of a situation and to see if there's a business solution short of a litigation solution, which is generally more time consuming, more costly, and oftentimes produces less desirable results than a workout.
Once you obtain the judgment, do you have any hints for our viewers as to good tactics to employ there?
Sure. I mean, there are many things that you can do once you get a judgment. You can and should attach property. You should get on social media and see what information this borrower or guarantors, what they're putting out there. In the age of information and information being available to everyone, there's plenty of room for error for borrowers to put out there something that they don't realize is tipping their creditor off that they have more in terms of assets than they're letting on.
Many debtors will respond to a default notice or a lawsuit with this, which is, just give me some time and I can pay it. How do you normally respond to that?
Giving a borrower time to make a payment is fine, so long as you're not putting your client in a worse position by doing so. And we have to always, as attorneys, keep in mind that it's not our decision to make whether or not somebody gets additional time. It's the client's decision. Our job as the attorneys, as we point in our article, is to make sure that we don't put them in any worse position. And we do that by filling any gaps or problems with the loan documents and using that time to enter into a forbearance agreement that provides some waiver language and even get some concessions that makes collecting the debt later on a little bit easier and maybe short circuits the process some. The most important thing is if this borrower or guarantor is owing your client money, it is likely not the only financial obligation they have. So it's very important for you to stay ahead of the pack and make sure that you are not putting your client in a position where they're going to be second, third, or fourth in line to collect on what's left of a very small pie. So getting some cash up front to pay for some time, that's helpful. Getting some concessions on the litigation process that may unfold after the forbearance period expires, that's important. Fixing some problems or holes with loan documentation when the credit was originated, that's important. And then just making sure that you're ahead of the other creditor pack in terms of reaching the finish line. That's always something to keep at the forefront of your mind.
If you want more information on how to collect a debt, see our article in the upcoming Wisconsin Lawyer.